The respondent was working for long. You are not Ramesh Ram, na? You are what?
Dhirendra Kumar.
Dhirendra Kumar.
Dhiren Kumar.
My lord.
Now, Ramesh Ram had worked for 9 years and he had acquired training also. Where was the occasion to remove him and appoint you?
My lord, order of State Appellate Tribunal dated 25/4/2022 as well as order of District Teachers Employment Appellate Authority order dated.
What is the order? Come to a State Appellate Authority's order.
My lord, the order
What
is
is
with
the
regard to.
fault?
My lord.
Next, 10 of the District Appellate Authority Lordship, which is affirmed by the Appellate Authority.
My lord.
That's all right, but what is your grievance?
My grievance is, my lord, initially I was appointed, thereafter removed from service, and respondent number 10 has been appointed on my place, my lord. Initially, my lord, I have worked for 1 year as a volunteer, educational volunteer, my lord, and grace of 20 marks has been given to me for that experience, my lord. That is at annexure, my lord. Annexure 1, my lord. I had worked for 1 year, my lord, under Vidyalaya Chalo Kendra. It's a scheme, my lord, and I had worked under that as a volunteer, my lord. For that purpose, my lord, initially, my lord, appointment process has been initiated, my lord, and in 208, my lord, petitioner along with private respondent has applied for the appointment as a Panchayat teacher in Gram Panchayat, my lord, Agartha, my lord, Farbisganj, Araria, my lord. Thereafter, my lord, despite of having higher merit, my lord, the case of this petitioner has been ignored and private respondent has been appointed, my lord.
The respondent was working for long. You are not Ramesh Ram, na? You are what?
Dhirendra Kumar.
Dhirendra Kumar.
Dhiren Kumar.
My lord.
Now, Ramesh Ram had worked for 9 years and he had acquired training also. Where was the occasion to remove him and appoint you?
My lord.
That appellate order, which was passed earlier on 22/1/2019,
My lord.
allowing your appeal, granting weightage to you.
My lord.
That order was passed in his absence, behind his back. He was not hurt. And therefore, the State Appellate Authority directed him to go back, and after that, DA has heard it and found that yes, he was entitled to continue.
My lord, but
And you, in your counseling, you did not submit any experience certificate.
my lord, I had submitted.
That's a finding of fact. We are not going to go into all this in while examining writ of. It's right.
My lord, I had also my experience certificate, my lord, that is annexure 1, my lord.
That is not for us to say. At that time, you did not place it. They come to page 55. They have now been placed on record as pleadings. The application form of the appellant does not indicate that any experience certificate was filed and the weightage was claimed.
My lord, that is.
You can't turn around and start claiming weightage after getting more intelligent.
It is also mentioned in page 47, Lords.
Okay, the petitioner by way of this appeal, this writ petition, seeks to assail the order dated 25/4/22 passed by the State Appellate Authority, whereby it has upheld the order passed by the District Appellate Authority, whereby the appeal referred by the petitioner was dismissed after the matter was remanded by the State Appellate Authority earlier. On an appeal preferred by the respondent.
Lords.
Para. These facts indicate that the petitioner and the respondent was appointed as a Panchayat teacher On 30th December 2010, a spate of litigation arose thereafter relating to selections, which included a petition filed by the petitioner. The District Appellate Authority, while its order dated 22/1/2019, allowed his appeal and directed the employment unit to grant weightage of experience in favor of the petitioner. Thereafter, he was given employment on 25th February 2019 and the respondent was removed. The respondent thereafter filed an appeal before the State Appellate Authority and contended that he was not given an opportunity of being heard. The State Appellate Authority accordingly remanded the matter back to the District Appellate Authority, and after considering the case of the petitioner vis-a-vis that of the respondent, the District Appellate Authority reached to the conclusion when the petitioner had no case as against the respondent, who was appointed 9 years back and had been continuing in employment without break. Moreover, a finding of fact has also been arrived at when the petitioner had not placed experience certificate along with his application forms. The experience certificate placed before the District Appellate Authority was much later in point of time, and on account of the same, weightage could not have been given at the time of counselling, which was conducted in 2010. Stop. The District Appellate Authority therefore rejected the appeal of the petitioner, which was challenged by the petitioner before the State Appellate Authority. The State Appellate Authority has again given a finding of fact, noticing that the petitioner that the application form of the petitioner does not indicate that any experience certificate was filed or the weightage was claimed. Keeping in view thereto, the appeal was rejected. Present writ petition has been preferred, challenging both the District Appellate Authority's order dated 31/12/2019 and the order passed by the State Appellate Authority dated 25/4/22. Para. I have considered the aforesaid aspects. This court, under writ jurisdiction, Article 2 to 7, has a limited scope for interference. It does not sit in appeal, and therefore factual aspects need not be examined unless there is a specific allegation of gross perversity. Having noticed the facts as above, this court is satisfied that there is neither any gross perversity in the order passed by the State Appellate Authority, nor any jurisdictional error is made out. On the other hand, factually, the order passed does not require any interference. Writ petition is wholly misconceived, is accordingly dismissed.